go on to pleadings. All right, City of Taylor versus Crystal Wiktorski.
Good, Your Honor. Matthew Zick for the people.
Your Honor, Bill Kolovis on behalf of the defendant, and I see the prosecutor has his festive holiday colors on. Your sweater.
Right off the bat, we've got holiday cheer colliding with courtroom tension classic, but don't be fooled by the festive sweater. What's about to unfold isn't exactly merry. This case is going to test how far the law can bend when someone claims they didn't understand the full consequences of their guilty plea. Let's see how that plays.
He's always festive.
Right. And here I came down here thinking I was going to see him in person. But it's like the movie stars. You see him on TV only.
All right, Mr. Clovis can keep buttering me up, but we did file a response in this answer in this case, Your Honor, and we are objecting to Mr. Clovis's motion.
Which, Your Honor, I was surprised that there was opposition to this, but that's okay. Your Honor, my client did not realize that when she pled guilty, that it would affect her employment. She's a CMA, been for 6 years. She was immediately suspended because this showed up on her record. And I believe she may have it under advisement. The problem is the under advisement was under 771, which is a conviction until you complete probation. And then it's removed if you satisfactorily do that. That's what I understand that she did in court with counsel. Your Honor, respectfully, we're requesting that the case be set aside, the guilty plea, not knowing that, or the case be reviewed and dismissed very early, like maybe today or very, very soon. So she has not had any employment whatsoever since this. She's lost her car because of this, bank accounts, and she has small children. So it's really caused an extreme hardship that she didn't realize this was going to cause. It was almost like that decision that came down about if somebody pleads guilty and they're going to be deported. Certainly it's not as strong as that. She also just told me, and she could swear to this if called upon, that she had asked her attorney at the time if it would affect her employment, and he said no. This was, I believe, a neighbor situation, correct?
Yes, pretty much.
That's all I have to say.
Mr. Zick, your response.
Your Honor, as Mr. Clovis, the collateral consequences are not an adequate or sufficient basis to allow the withdrawal of a guilty plea. And Mr. Clovis correctly cited that there is a special carve out for that, and that is for immigration consequences. But other than that, Your Honor, employment consequences or other collateral consequences are not a sufficient basis if the plea process was appropriate, which I believe it was in this case, that she was represented by counsel at the time of the plea. The defendant was advised of her rights appropriately under MCR 6.610 F8. And Your Honor, people object to any kind of withdrawal at this time is it would cause substantial prejudice to the prosecution for the reason, as I stated in paragraph 5, the people are very unlikely to be able to proceed with this case if the plea was set aside. This matter has been closed. My understanding from speaking on the phone with the victim at time of sentencing is she was moving out of state. And Your Honor, we're asking that the plea stand as given by the defendant when she was represented by counsel, by predecessor counsel.
Your Honor, the hardship is of 6 years schooling and employment, and now she cannot be employed in that field. She has a defense, but she thought with court-appointed counsel, she had limited funds, of course, raising children on her own, and she thought she would just plead guilty to an offense, be under advisement, and then dismissed. She didn't know that it's a conviction And then after a period of time, then it's removed from your conviction. And she didn't understand that. I don't know why it's being fought so hard by the prosecutor.
Because he's indicating that it'd be unfairly prejudicial to his ability to prosecute in the future because a complaining witness is gone.
Well,
Out of state. But Mr. Kolobis, like if you look at the rule, right, we're talking about a motion to withdraw a plea after sentencing. And I listened to the record yesterday on this case when I got the motion. And I understand there are collateral consequences to all kinds of things, but the constitutional rights that she was that I am mandated to ensure that she understands were all read to her on the record. We went through it. It was, if you look at the rule on how I'm supposed to take.
Okay, pause for a second. This is key. Under advisement sounds like a legal safety net, but here's the twist. Under Michigan law, a 771.1 deferred sentence still counts as a conviction until you finish probation. So even though the defendant thought she was in the clear, it hit her job like a ton of bricks. Have you ever signed something without fully realizing what it meant? Yeah, this is that, times 10.
The plea, I asked her everything I was supposed to ask her, and she responded to all of those questions accordingly.
I understand, Your Honor, as to any hardship or prejudice, by Zoom, which prosecutors appearing now, by Zoom, the witness could give testimony by Zoom, wherever she's at. I've had people in Europe give testimony, Your Honor, and if not, if the court is so inclined not to set aside, we would ask after all these months that the court do the review. She has not been in trouble and go forward and dismiss it early.
Yeah, and Mr. Kolobis.
Oh, it's been over a year. Okay.
No.
Your Honor, I believe the plea was taken back in June.
I'm looking at the jail task force legislation on early probation discharge, and assault and battery is not one of the listed offenses.
Well, I would ask the prosecutor, can we please amend the plea as to the under advisement period of time, or 771. This offense happened approximately a year ago, and she was on probation in June. So she's coming up to 6 months.
No, she started probation. Yes, I think her 6 month is in January.
I would just ask Mr. Prosecutor if you'd be so inclined to amend the condition if the court accepts it to whatever 5 months or whatever it may be, prior to Christmas maybe, just so she can get back to work. They suspended her pending this period of time, and she has no.
I believe the appropriate vehicle for Mr. Kolobis, as he knows, would be to file a motion for early discharge of probation, even though it's not entitled under the statute. In any case, a defendant always has the ability to petition the court for early discharge if in full compliance, but that wouldn't be something that the people would be involved in. That's post-conviction.
Yeah, I don't know what the status of her probation is. I know I haven't seen her on violations to my knowledge, so I can only assume that she's doing what she needs to do, or she would have been sent up here to see me. So she's eligible.
Wow, what a finale. We've gone from legal technicalities to raw human emotion, all wrapped in a Merry Christmas that feels anything but jolly. The judge's hands were tied by the law, even if his heart leaned toward mercy. So here's the big question. Should courts have more flexibility when someone clearly didn't understand the impact of their plea? Let me know what you think, justice or just procedure.
For termination at the halfway point under the jail task force legislation. So, and she was sentenced on 7/19, 8/19, 9/19, 10, 11, 12. So on January 19, she's eligible for early termination. And if she's complied with all of the terms of probation, I would certainly grant that. I have probation officer in the courtroom looking it up, I know, but Mr. Pease, I'm looking at the statute. The DVs.
Oh, that was.
I can't, oh, you weren't? I was like, I know, because we've had this discussion about assaulted cases before. But she's eligible, Mr. Kolobis. I have to, with deny the motion to withdraw the plea respectfully. I think the court rule on this is abundantly clear. And after sentencing, it's a high standard to me. And you know, I listened to the plea, and if you want a transcript of it, you're happy to have one if you intend on
I trust your honor.
appealing up, but I had Miss Maudlin pick it up yesterday to make sure that everything in the plea was right. And
I guess I was just looking at equity on this and hoping the prosecutor would have pulled his heartstrings on this, but if he wants to stay strict on
Prosecutor's
it.
got to follow the law, Your Honor.
well, look, you two can fight it out in the hallway if you need to. Listen,
I'm okay.
I have to follow the law. I'm governed by the court rules. I feel very sympathetic to Miss Witworski, but this is an assaultive case, and she kind of got herself into this. I mean, the allegation was that she's at a gas station, she's punching someone in the face.
No, this woman was in my home now.
Over a guy.
She was in my
The
home,
woman
in my
was
bed
in her
after my
house.
16-hour shift
Oh, she was in her bed after she came home
with my kids.
with the children. I wish she would have pursued it further, but she had court-appointed counsel, and I didn't represent her at the time. She has no money to do an appeal, so I guess to the prosecutor, Merry Christmas.
All right, file your paperwork in January.
All right, thank you,
Consider
Judge.
it.
All right, you have a good day.
Thank you.
Have a good Thanksgiving.